The opinions, views, and conclusions expressed in this show are those of the show host and co-host and do not necessarily reflect the views or positions of KPFV FM or its affiliates.
The Seventh Amendment Hour, a discussion of the Fifth and the Seventh Amendments. Now here's your host, Gary Bergman.
Don't believe in what we're telling you, you as a not dive into troubles. Know that France is in Australia is officially in a recession now. Hasn't been since 30 years since they've had a recession, they said. And these recessions are going to be global, in case you haven't figured out. Remember this COVID-19 pandemic, as we call it. They started working on it back in 2005. Special treaty done. So this ain't nothing new. Well planned, just like the Second World War, by the way. This ending of the Second World War, the largest corporate war for profit for millions of Americans. Thousands.
With.
Well, the Second World War.
Oh,
I don't know how many.
It didn't get over a million. It was
okay, so
over
hundreds of thousands, and millions in the worldwide. I mean, people lost their lives. They thought they were all fighting for a good thing, but it was nothing but a war of profit. Tankers in the big war industry.
We talked about World War I and that.
War's a racket. Yeah.
War's a racket.
So he proved how much profit was made during the First World War. Just imagine how much they made during the Second World War. And remember, Roosevelt was tried as a war criminal by proxy. So he was found guilty of war crimes. Especially bombing Japan the way they did that. That was a war crime. And what we did to Germany was a war crime. So, a little announcement here. We're still looking for people for the common law grand jury. We think we just found about 3 more. We're stepping up finally. And we're also looking for some youthful patriots to do another special show we'd like to put on. We already found brothers to do a show for us. I think they're in their 20s. They're well versed on here. Be happy to do it. And a little notice, we're having a Labor Day rally to thank the building trades and people that have skilled craftsmen that have built this. We're holding it at 8 o'clock. So a little notice here, Nevada Republic Labor Coalition is putting on a rally to support the building trades of America for building America a great nation. We owe what we have today to the men and women, the skilled tradespeople. Everything you touch was made available to you by the sacrifices that men, women, and their families make daily. If you don't think it a sacrifice, you never worked the trades.
Exactly. I just want to remind you that your former government there, under corporate President Obama, reminded you didn't make that, government made it. No, that's not true. The trades built that. Government didn't do it. People did.
Yeah, I know. I can remember 2 times I almost nearly got killed. That wasn't very nice. Everything you take for granted was done with blood, sweat, and tears, limbs, and sometimes death of the building trades members. Where is your gratitude? Wars for profit could not be fought without these building trades members. You couldn't have the shipyards, the ships, the weaponry, the uniforms, the food. None of that could have been done without building trades making the factories. So keep that in mind. You can't even do a trip on your light switch to see where you're going or put that coffee pot on unless it was out of building trades building those powerhouses. So
now's our opportunity this coming Monday to say thank you to these fine men and women who have built everything we touch, everything we work with. We're going to be out there starting at 8 a.m.
Well, it's cool.
Well, it's cool. We're not dumb. We're not going to be out there at 3 o'clock in the afternoon. The corner there of 160 and 372 in Pahrump, Nevada. Gary and I both be out there. Got a good civil flag, bring it. Get a sign thanking a tradesperson, bring that. If you were a tradesperson, wear your t-shirt.
Or wear your hat.
Wear your hat.
And if you're a welder, wear your welding cap. You know, it's kind of unique to our trade, our welding caps.
Absolutely.
And
So we got some breaking news. Go ahead, Gary.
yes, this is immediate release today, September 2nd, 2020. Rutherford Institute defends right of firearms training facility to reopen, warns against attempts to use pandemic to curtail gun rights.
We expected this. We expected government to try to curtail any and every right it can get its hands on thanks to the pandemic.
So finally, Constitutional Law Institute has stepped up. And I mean, there's so many lawsuits that could be going right now, but this is the one they went. They went after the Second Amendment. So the Rutherford Institute has come to the defense of a Nevada firearms training facility threatened with fines because of its plans for reopening. In a letter to officials with Nye County, Nevada, on behalf of Front Sight Firearms Training Institute, Rutherford Institute attorneys warned local officials against abusing government authority during the pandemic to curtail Second Amendment rights.
Exactly. The Second Amendment's just important as that First Amendment. You're allowing rioters, allowing protest. You really can't do a whole heck of a lot to curtail Second Amendment rights.
So, pushing back against claims by Nye County officials that Front Sight faces fines and other penalties due to its plan to allow more than 50 persons in its training facility, Institute attorneys point out that firearms training designated as essential infrastructure is exempt from the governor's emergency restrictions.
Absolutely. I would say it's essential, wouldn't you, Gary?
Oh, yes, yes.
Particularly since they're providing a lot of the training to, the folks that are supposed to be enforcing the law and to the military contractors. Hey, I think that was essential, right?
Right,
Wars
right.
for profit.
So, moreover, attorneys assert the Front Sight Firearms Training Institute is exempt from gathering restrictions and mask requirements imposed by the Nevada governors because state law forbids the use of emergency powers to prohibit activities at the core of the constitutional right to bear arms, including training and the safe use of firearms.
Yep, so that's good.
Okay, as the courts have recognized, the constitutional right to possess firearms protection wouldn't mean much without the training and practice that makes it effective, says a constitutional attorney. John W. Whitehead, president of the Rutherford Institute and author of Battlefield America, The War on the American People. That's exactly what's going on. While the government is struggling to formulate an appropriate response to COVID-19, it cannot use this pandemic as a justification of curtailing fundamental rights. That's right. We've been talking about that. The Constitution still applies.
Absolutely. And I wish them the best of luck in trying to bring down the government military or the government complex on this, trying to curtail the ability to defend oneself.
So make the government play by the rules of the Constitution. Support the fight for freedom.
That's a great segue here into our content today, talking about these.
And you can go on. I'm trying to find. You can go online. You want to get you can go to Rutherford Institute's letter to Nye County is available at www.rutherford.org. www.rutherford.org. You can get on there, and they're working in conjunction with Leslie Mark Stovall of Stovall and Associates. That's who's handling. That's working with them for the Law Institute. So you know what? If they're working with Rutherford on the Second Amendment, maybe Stovall will help on these other constitutional issues that are being violated every day because the non-believers are walking around like sheep doing whatever being told. They don't research their rights or privileges. So, it's time to wake up. Are you going to stand in line and get these vaccinations and these implants put into your hands and get that special, what is that, immunity passport?
Yes, the contact tracing and I've got my immunity paperwork.
So, are you going to play that game too? Your kids won't be able to go to school. So who cares if they can't go to school? School them at home. Don't play the game. That's the mark of the beast, in case you haven't figured out. The mark of the beast. The time is now. If you want to be a non-believer, you ain't going to make it through these troubled times. It's already been designated. Only to believers like us are trying to educate you because we were told to educate you. We will be the survivors. We'll be restoring Lord's kingdom. So Start challenging the legality of any attempt to fine or restrict your constitutional rights. Now's the time.
Absolutely. I want to remind us about something one of my favorite English philosophers teaches us. The only thing necessary for the triumph of evil is that good men do nothing. The forces of evil and oppression are absolutely tireless in their effort to break down the right and the just. Like I say in my metaphor of the sandcastle in the ocean, it's the only thing being equally tireless with our sandcastle that it keeps standing. Only through coming together in the same organic societies that we learned from Edmund Burke that we can prevail. So
we will continue on with the U.S. codes that every American should know. We covered U.S. Codes Title 18, Section 4, 241, and 242.
This is what we're talking about, using their own rules against them. We're going to keep educating you here, starting with U.S. Title 18, Section 872. Extortion by officers or employees of the United States Corporation.
So Section 872, whoever, being an officer or employee of the United States, all capital, or any department or agency thereof, are representing him, herself to be, are assuming to act as such under color or pretense of office or employment, commits or attempts an act of extortion, shall be fined under this title or imprisoned not more than 3 years or both. But if the amount so extorted or demanded does not exceed $1,000, he shall be fined under this title or imprisoned not more than 1 year or both.
You ever wonder why a lot of things are under $1,000?
There was a town in New Jersey not too long ago. I was reading about 3 of their officers. Feds got them for this extortion. They ain't coming out for at least 10 years, and those fines were really heavy.
So, in order to understand this section of the U.S. Code, we need to pause here to take a look at the definition of that legalese word that's used. Extortion. That's the criminal act here that's pledged. Of course, we go back to our old friend, Black's Law Dictionary. Go get yourself one.
All right, sixth edition.
It defines extortion as the obtaining of property from another induced by wrongful use of actual or threatened force, violence, or fear, or under the color of official right. A person is guilty of theft by extortion if he purposely obtains property of another by threatening to inflict bodily injury on anyone or commit any other criminal offense, or accuse anyone of committing a criminal offense, or expose any secret tending to be subject a person to hatred, contempt, or ridicule, or to impair his credit or business, or to take or withhold action as an official, or cause an official to take or withhold action. To keep going, bring along or continuous strike, boycott, or other collateral unofficial action if the property is not demanded or received for the benefit of the interest the actor proposes to act, or finally testify or provide information or withhold that testimony or information with respect to another's legal offense. So that's what we're looking at here. It has also been defined as corrupt demanding or receiving by a person in office a fee or services should be performed gratuitously, where the compensation is permissible of a larger law adjustment, or when a fee is not due. The term applies to a person who extracts money either for the performance of the prevention of injury or the exercise of covers the obtaining of money or other property by obtaining on fear or credulity, or by the promise to conceal the crimes of others. The term is comprehensive or general sense, signifies any oppression, color, or right, strict technical sense. So that's what we see here. That's what we need to understand it could be going on. So if a member of the local racket shows up, and I know I'm monopolizing a little here, Gary, I want to make this absolutely clear to our viewers. A member of the local racket shows up at your business and tells you you don't pay them fire insurance money. Do you smell smoke? A bad thing might happen to you, or your family, or your business. That's extortion. According to some people, if that person who's doing this Has a specific costume on or a particular name badge, though, it's okay. I say this because every time you take out a permit, charged a fee, you have to pay a tax. Government demands under threat of force of people in a particular costume that you pay it. Fail to pay it, lose your home, your property, your car. Heck, they may even shoot the family dog. Or if you dare resist in any way, including asking why, your life or the lives of your family may be forfeit. Think for a minute about the statement that's bandied around. Just do what they say, nothing bad will happen. Or take it up in court, not on the street. What that says to you is as long as somebody is a part of a particular group or in a particular costume, they can walk up to you and demand, under threat of death, to obey them for anything at any time. That's not freedom. That's a police. All of these things are extortion.
And under the War Powers Act, shooting the dog, family dog, federal crime. Even stealing your car. So remember, we're technically still under war right now. War Power Act still active.
Absolutely.
So USC Title 18, Section 1001, statements or entries generally. Section 1001, A, except as otherwise provided in this section, ever in any matter in the jurisdiction of the executive. Remember, executive, legislative, or judicial branch of the corporate government. Now, the governor's under what branch? Executive.
Absolutely.
Mandate to come under judicial. And you cannot cross three branches. You can't be a governor and jump over there from the executive to the judicial, or jump from the executive to the legislative. It's illegal.
Or vice versa. And there's actually right now a federal lawsuit against the state of Nevada, the State of Nevada Corporation, dealing with holding an office in the legislative branch as well as being an employee within the executive.
But I hope that somebody wins on
Oh,
that.
absolutely. It's patently against the Nevada corporate constitution, and it's a violation of that separation of powers.
So just telling you right that tells you the governor mandate, which he has no right to do, is unlawful. It's bullshit. Anyway, government of the United States knowingly and willingly, 1, falsifies, conceals, or covers up by any trick or device a material fact. Makes any materially
all the time.
Yeah. So number 2, makes any materially false, fictitious, or fraudulent statement or representation. That's a mandate. Number 3, makes or uses any false writing or document, knowing the same to contain any materially false, fictitious, or fraudulent statement or entry. Here we go. We're back to the mandate. Shall be fined under this title, imprisoned not more than 5 years, or if the offense involves international or domestic terrorism. Well, right now it's domestic terrorism. Imprisoned not more than 8 years, or both. So the governor should be locked up as a terrorist. And the matter relates to an offense under Chapter 109A, 109B, 110, or 117, or Section 1591. Then the term of imprisonment imposed under this section shall be not more than 8 years. So, there's laws out there to protect you. There's rules, there's regulations, there's codes.
Absolutely.
You have to know this stuff. Don't rely on a bar member that took an oath to the crown to tell you your rights. Wake up.
You got to remember that same lawyer that you're relying on to give you good advice, they're educated by the same state that's charging you with something. They're licensed by the same state that's charging you. They're good buddies with the prosecutor. They know that judge behind the bench. And hang on, they're all getting cut a paycheck by the same people.
And they're designated as an official of the court.
Exactly. So that's some powerful stuff there. This section of the U.S. Code makes it a crime to cover anything up within the official record of the government. Any attempt to cover up or change the truth within these records is a crime and must be guarded against. And we're the guarantor of that. We're the one that guards against that by making sure our records are the ones that are accurate and then comparing those to what the government has.
I think there was a case over here in Nye County Courthouse regarding the drug traffic or drug court.
Yes, sir.
There was some falsification of records over
there. Absolutely.
That's another title.
Exactly. Now, sadly, we often see the excuse of national security being bandied about to be used to conceal or keep the truth from us, and us, the unwilling participant in the great government machine. You know, they're keeping the Kennedy report secret for till 2050 something. Why is that so important? Why is that so secret that we need to use national security to keep the American people from knowing the truth?
Okay.
Well, yes, exactly, the CIA's involvement. But, I can't say that for certain. Reports are kept classified for decades longer than they need to, and releases are redacted, and it falls upon the requester to sue the government to get many of these records released under the Freedom of Information Act. They should be volunteering this stuff too. Like many of these statutes, I would like to see this one acted more vigorously upon. Though we have seen some people serve time over this, but not as many government functionaries as I'd like to see. Obviously, this particular statute is good enough for Martha Stewart, because this is the one she served time on. Martha Stewart, Bernie Madoff, and Jeff Skilling all served time over this. I haven't seen any good government official from the top to the very bottom be convicted of this.
Yep.
Good to see one prosecution against someone who files a false report.
Hillary.
A judge that misrepresents the law in court. Prosecutor, Kamala, that presents or withholds exculpatory evidence, Kamala. No one else, no political party, like I said, they trot her out as vice presidential candidate.
Yeah.
Now I want to bring a name up. Kevin Cooper. Mr. Kevin Cooper sat on death row because Miss Harris covered up the DNA evidence, and over 1,000 other cases were dismissed because it was discovered her office covered up an issue with the crime lab. Maybe she was trying to cover up Willie Brown's DNA.
And the Democrats want her for a vice president?
Hey, they figure you get her right up at the top there, she can monocle with the best of them.
Yeah.
No one has faced any charges over this. They would love it, but heck, the rules are for Martha Stewart, not for them.
So we have U.S. Code, Title 18, Section 16, subordination perjury. This section, whoever assures another to commit any perjury is guilty of subordination of perjury. That's, in other words, when that judge is asking you if that's your name in all capital letters, you're telling him no, and he keeps badgering until you say yes. That's right there.
Exactly.
He's forcing you to perjure yourself.
Trying to make you commit perjury because you are not that corporate entity that's represented by the all-cap name.
Yeah, you don't own that capital name. That belongs to them. So anyway, and shall be fined under this title or imprisonment not more than 5 years or both. Get something in this room here.
So this one here, ladies and gentlemen, speaks for it. It's simple. It's a crime to push someone else to commit the crime of perjury. But how often does this happen when a person is pushed to fill out a form that says very clearly at the bottom, it says, under penalty of perjury, the easy way?
Yeah, that's not lawful anyway.
The way that's going to slip through. The way that's not the right or truthful way. Every time that an official, or even someone else for that matter, pushes you to make an untrue statement, it's a crime. And rightly it should be.
Right. All right, so now we got U.S. Code Title 28, Section 1746, unsworn declarations, penalty of perjury. Wherever any law of the United States or under any rule, regulation, order, or requirement made pursuant to the law, any matter is required or permitted to be reported, evidence established, or proved by the sworn declaration, verification, certificate, statement, oath, or affidavit of truth, and writing of the person making the same. Such matter may, with like force and effect, be supported, evidence established, proved by the unsworn declaration, certificate, verification, statement, and writing of such person, which is subscribed by him, her, as true under penalty of perjury and dated.
I'm really glad Gary's reading this stuff because I really have a hard time reading these laws, and so do most people, and they're intended to be that way. This is what we're talking about when we talk about legalese being a true foreign language. Now, it's marginally compatible with English, just like Scots and English are moderately compatible, French and Spanish, but understand the meaning of these words. So this statute here is a two-edged sword. And most of the forms we're forced to fill out have language at the bottom on that last page where you need to sign stating you certify that the above is truthful under penalty of perjury. You were saying that's not legal, Gary. You want to explain that a little bit?
You actually got to take a sworn oath. That's just bullshit. All it is trying to make you think you're actually signed, but what you're doing though, you're lying to begin with by saying that. I mean, they caught you a double-edged sword.
Exactly.
So you never want to actually read it. Cross it out. You have the right to do that before you sign.
Exactly. You have the right to modify any agreement that you are making with somebody.
That's right.
Before you both sign it.
Take a big black felt pen or red pen and cross it out.
Exactly. And if they agree, if they sign it after that, that is a binding document. Right. So this applies not only to we the people, but to any government functionary that makes any mark on that paper. To make any changes above that line, let's go right back up to the U.S. Code Title 18, Section 1001. Because now they've made, or an attempt to, falsify this document.
That's right.
And it happens all the time. Heck, when you pay a visit to the DMV, when you pay a bribe for a permit, when you deal with any of the various functionaries of government, you best believe that this de facto government has no issue prosecuting you to the full extent of their law for this.
That's a moneymaker.
If the prosecution is in their favor. But if they make an error, they make an untrue statement, nothing's ever going to happen to them unless you spend hundreds of thousands on permission to sue them over the issue. And you may recover something monetarily, but no one's going to go to prison. No one's fined. They don't follow their own laws. They'll be paid off with somebody else's extorted tax money. It's unfortunate, but I think that's the way it is.
So these are, this is U.S. Code Title 42, Section 1983, called the Civil Rights. And they're just as important as Title 18, 4, 241, and 242. Civil action for deprivation of rights. Every person who, under the color of any statute, ordinance, regulation, custom, or usage. Now, you remember what we're saying here. We're not saying law. We're saying corporate rulings.
Exactly.
Regulation, customs. Yeah. That's corporate. You're not a member of the corporate. Of any state or territory of the District of Columbia. Now, District of Columbia. Now, we're having a little problem with District of Columbia right now. We'll talk about that further. Subjects are clauses to be subjected any citizen of the United States, 14th Amendment citizen, or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution clause shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress, except that in any action brought against a judicial officer or an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or a declaratory relief was unavailable.
Yeah, like I said, it's a foreign language. I'm glad Gary's floating in it. So it's convenient, isn't it? Except for any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity. Heck, sorry we deprived you of your rights in the court system, but you get no relief. You don't even get an injunction, no monetary compensation, not even an apology. It exempts itself from the law, like they do in a lot of laws. We forgot to let you know we were in possession of exculpatory evidence that went and put you in a cage. But heck, you don't get any relief from that. You have a nice day, don't you? Dang. So who are these people exempt from this? Back we go to Black's Law Dictionary. Justice of the peace, so this is who these court officers are. Justice of the peace, magistrate, or a judge, or any other officer of the court. An officer of the court is a person in court, usually the judge, or the magistrate who holds the power to administer justice. These people are allowed to make acts of omission, even deliberate omission, in the commission of their duties. But everyone else, the police, the various executive branch officers, the functionaries, all the way up to the executive themselves, members of the legislature and their staffs are all bound by this statute. Big issue here is knowing when it happens. The only way that people know when this happens is knowing what their rights are. And far too many people are unwilling to do their homework. Like Gary and I tell you, we can only hang on to you for about an hour. No, you got to go out and do your homework on this. Get their understanding of what the right. They get their understanding of rights from a cop show on TV.
Yeah.
They look to Law and Order.
Yeah, don't listen.
Or old LA Law or CSI to teach them what rights they have. This is propaganda. It only shows what the government wants you to see. Remember, they're part of the government media complex. They're licensed, they're bought, they're owned by parts of the government. Don't believe what they have to say. That's a good word for our day, propaganda. It shows you on these TV shows the police, the prosecutors, and judges in a very positive light.
Yeah, they make them look good.
Like some cop that plays basketball with an urban youth, or TV show that shows you the tireless, overworked, underpaid public servants of justice that are just tore up inside by the injustice of the system. Picture Mariska Hargitay, Gandhi was some poor assaulted girl at SVU. And we're supposed to believe the entire system works like that. No one ever mentions the time that that young girl's raped by the very cop that's investigating the case, or pimped out by the district attorney. No one ever talks about those. But they happen all the time. Heck, there's right now, they just found 4 more children. 4 more. So there are 4 plus the original 8 that have been raped by the it was New York representative for the EPOE. EPOE? Brotherhood, the Protective Brotherhood of Police.
Well,
Police Union.
California Highway Patrol had a few other officers raped things. Pretty good at it.
They don't talk about that. They want you to see
hide it.
the good stuff. It's unfortunate that that kind of stuff happens. But I'm not saying everybody's a bad person out there. But I'm saying they do exist. You don't see that on TV.
So we have U.S. Code Title 42. Now, this is Section 1985. Conspiracy to interfere with civil rights. Obstructing justice. Intimidating, yeah. Party, witness, or juror. If 2 or more persons in any state or territory conspire to deter by force, intimidation, or threat any party or witness in any court of the United States from attending such court, or from testifying to any matter pertaining therein, freely, fully, and truthfully, or to injure such party or witness in his person or property on account of his having so attended or testified to influence the verdict, sentiment, or indictment of a grand or particular juror in any such court, or to injure such juror in his person or property on account of any verdict, sentiment, or indictment lawfully asserted to by him, or of his being or having been such juror. Or if 2 or more persons conspire for the purpose of impeding, hindering, obstructing, or defeating in any manner due course of justice in any state or territory, intent to deny to any citizen the equal protection of the laws, or to injure him or his property for lawfully enforcing or attempting to enforce the right of any person or class of persons to the equal protection of the laws. Private property license plates.
Oh, absolutely. I actually take this one step further. I'm going to point to those 3 officers, those 3 cowards out of Kentucky. Now, the young man who shot them, rightfully, when they broke into his home and murdered his girlfriend, wearing plain clothes in an unmarked car in the middle of the night, looking for a guy they had captured 3 days earlier who never lived at the address. Then after they murdered her, drove away, didn't call it in. Now, they're trying to get him to plead guilty to injuring that officer. And in that plea, they want him to say, yeah, my girlfriend, the EMT, the award-winning EMT with never a blemish on her record.
That one.
Yeah, the Breonna Taylor case. That she was involved in a heavy criminal enterprise. That's what they're demanding of him, that he gets the right to plea out.
That's terrible what they do.
So that's what they're doing right now. They are using intimidation to try to force this young man's hand.
Right, against the law. So here we got number 3, depriving persons of rights or privileges. 2 or more persons in any state or territory conspire or go in disguise. Here we go, on the highway, unmarked cars, or on the premises of another for the purpose of depriving either directly or indirectly any person or class of persons of the equal protection of the laws, or of equal privileges and immunities under the laws, or for the purpose of preventing or hindering the constituted authorities of any state or territory from giving or securing all persons within such state or territory equal protection of the laws. If two or more persons conspire to prevent by force, intimidation, or threat any citizen lawfully entitled to vote, giving his support or advocacy in a legal manner toward or in favor of the election of any lawfully qualified person as an elector for president or vice president, or as a member of Congress of the United States, or to injure any citizen, person, or property on account of such support or advocacy in any case of conspiracy set forth in this section, one or more persons engaged therein do or caused to be done any act in furtherance of the object of such conspiracy, whereby another is injured in his person or property, or derived of having or exercising any right or privileges of a citizen of the United States, the party so injured or deprived may have an action for the recovery of damages occasioned by such injury or deprivation against any one or more of the conspirators. That's why you need Black's Law.
Absolutely. Welcome back to Legalese. So this would apply to our good and dear friends Antifa. It would also apply to those good and dear folks, out there hurting people on behalf of the Trump campaign. That's what this is talking about. Going in disguise to deprive people of their right to vote. When you're wearing a mask and shouting at somebody, intimidating them with a weapon in your hand, you're probably guilty of that thing above there. But also, heck, try talking about jury nullification.
Well, the easy thing to stop in these riots is just go and see the bank accounts in this country. He's got them all around the world. George Soros and his kid.
It would dry up real quick.
All that money comes from Soros, a Romanian. He's actually a citizen of Canada. So,
and crash the British pound.
There's some executive orders that they'd be able to use to seize his funds. That just come to a stop. Nobody be getting paid no more.
So, coming back to this same thing, try talking about jury nullification in any courtroom in the country. See how fast conspiracy between the judge, the bailiff, and the prosecutor happens to deprive you of your rights of free speech and your rights that are codified in the Constitution of being able to judge the facts of a case, independent of the instructions of the judge. Look at the case of Keith Wood. Father 8, works for an insurance broker. This guy's no slouch. Was sentenced to 1 year in jail and a $1,000 fine. You know what his crime was? He was passing out flyers near a courthouse, not even on courthouse grounds, claiming your right to jury nullification. The court conspired to deprive him of his First Amendment right, as well as deprive the jury of the knowledge of nullification. And how about Anders Gerardo, security guard, murdered in L.A. by L.A. County Sheriff out of Compton. He had his hands up, was on his knees when he shot in the back 7 times by deputies. They conspired to deprive him of his civil rights, of his right to life. Reported by a whistleblower that the deputies at a Compton station who executed this young man were chasing ink. That's right, they were trying to impress a gang within the sheriff's department called appropriately the executioner. They conspired. They all got together to do this. Kill this young man and cover it up. They could join a gang. Heck, even I've been a victim of this. I was threatened with contempt by a judge for even mentioning during jury selection, jury nullification, that I believed in the right, 7th Amendment right, actually, of a juror to judge the fact. Threatened with imprisonment, seizure of my private property, because I knew my rights. I knew the rights of the jury. The judge and other officers of the court worked together to intimidate me into not serving on that jury and not spreading the truth. Now, I admit this is weak sauce on my part. I freely admit I've not always been as principled and educated as I am now. I acquiesced. I left under threat. Didn't take a stand. I'm guilty in my younger days of not willing to risk for the sake of justice. And I know every excuse, justification, rationalization that you have in your mind out there. I have a family to support. I have a job I need to get back to. I don't want to get involved. My folks will be mad. Not my problem. Remember, Shell started off today, dear friends, with all that is required for the triumph of evil is that good men do nothing. Take a stand. Take it, and men like me stand by your side.
So remember, U.S. corporate citizens, Amendment 14, do not have rights. You only have corporate privileges.
Right.
Only American state nationals have rights. And if you want to get in the immigration nationalization paperwork, you can find that there is two types of citizenship.
Separate passports.
Yeah, two separate passports. American state nationals follow the Constitution. Only the states have the right to make citizenship. The ones that say they're U.S. citizens, well, they follow the foreign corporation that's headquartered out of a foreign enclave called the District of Columbia, run by the Crown and the Vatican. So you're actually foreign agents. You registered as foreign agents in the Foreign Registration Act. So now we're back to U.S. Code, Title 42, Section 19.6. Action for neglect to prevent. Every person who, having knowledge that any of the wrongs conspired to be done and mentioned in Section 1985 of this title are about to be committed, and having power to prevent or aid in preventing the commission, neglects or refuses to do. In such wrongful act to be committed shall be liable to the party injured or his legal representatives, for all damages may be recovered in an action on the case. Now we're talking about cops, bailiffs, district attorneys, judges.
Exactly. You have to have in order to fall under this, you have to have what's called a duty to act. You know, you and me on the street, we don't technically have a duty to act other than our duty to our conscience and to our God. But there are people who legally have a duty to act in this particular case. Like Gary said, it's bailiffs and police officers and officers of court, except government employees. That's who this all applies to.
So any number of persons guilty of such wrongful neglect or refusal may be joined as defendants in the action, or if death of any party caused by such wrongful act and neglect, legal representatives of the deceased shall have such action before and may recover not exceeding $5,000 in damages therein for the benefit of the widow of the deceased.
I really think that's a low number, Gary,
I do think, too. That's what it was listed. If there be no widow, then for the benefit for the next of kin of the deceased, no action on the provisions of this section shall be sustained which is not commenced 1 year after the cause of action has occurred.
Right.
Now that's just one section. Now there's other sections that have penalties too. You start adding up all these different sections. You know, one violation of a Title 18 is $250,000.
Right.
So I mean, we got to just look at the difference in what the penalties are. That's like a cheap.
Oh yeah, exactly. So I got a serious question on this one. When was the last time anybody heard any member of the court, any police, any jury, any judge, any bailiff seem to stand around at every atrocity being charged under this statute? You know, it seems to me that there will be guilty of this failing to prevent the deprivation of rights under color of law. And I'm given some excuses every time. And I understand. It's very hard to be out there on the streets. I did a long time out there doing good stuff as a medic. You know, the good cops are scared of the bad. I can understand that. The bad ones are pretty freaking bad. They're scared the bad ones won't back them up. They're scared the bad ones will hurt them or their families. Rightly so. Just look at Adrian Schoolcraft. I consider him one of these good cops. He recorded the bad ones, making the mistake of he made the mistake of taking it to internal affairs. He was harassed to the point of reassigned to a desk job. Then he was involuntarily committed on a 5150 hold to a mental hospital, where he remains there to this day. This was back in the 90s. This poor guy is serving time for standing up against this. You know, one of the daily violent assaults that happened dealing with nationwide protests. You know, what about Martin Guigano, partially paralyzed because he was in the way of the police line. We saw this video on the news dozens of times. The cop walking up to him and shoving him. 75-year-old man shoving him down. Hits his head on the ground, bleeding out the ears.
Yeah, what's
I don't remember. No, it was back east.
yeah, it's not,
No, it's a totally different case. This is the old man. He was there, I believe, on the steps of Jefferson Memorial.
and all those cops are coming down.
Yeah, they're walking down. The one shoves him over.
Shoved him, and
bang,
then one tried to get down to help, and tried to pick him up.
supervisor picked him up and told him to stop.
No.
This poor guy has been deprived of his ability to walk. Right to free expression. On the contrary, it seems there was one that stopped, and like I said, his supervisor pushes him away. Because they had the audacity to charge the one cop, 57 others resigned. And what I got to say to that is good riddance to bad rubbish. If you're going to resign over trying to hold somebody accountable for something like that, you don't really belong.
That's right.
And my question is, why aren't those 57 being brought up on charges? Because that sounds to me like a conspiracy to extort the city into dropping those charges.
Point.
If we were to enforce these things, maybe these good cops would have a fighting chance. Maybe these good cops would actually have an opportunity to clear out the dead wood, to clear the bad guys out.
Now, this is something you need to listen to very carefully here. By the way, those last sections of civil rights of the Title 42, that's covered by the Department of Justice, the Human and Civil Rights Division. They have their own department that handles those affairs. So if you have a complaint, you just write to the Department of Justice, file a criminal complaint against these officials, and feds will come in and take care of it.
Hopefully they'll come in and take care of it.
Yeah, hopefully, right. But you also have the Human Rights Bill of Rights and also the International Bill of Rights, which both very good articles that you can use.
Absolutely. Take it to the International Criminal Court in Brussels, Belgium.
So, no, what you do, you start with the Department of Justice.
Oh, that's right. You got to start internally.
And if they refuse to
out.
do it, then you just move it right over to the International Court, and they'll pick up where the feds wouldn't do it. So, delegated authority. With no constitutional authority to do so, the Executive Congress be created under martial law by the CEO of the United States of America Incorporated. Lincoln created a separate form of government for the District of Columbia. And to this day, it's still a foreign enclave.
The 10-square-mile enclave surrounded by reality.
That's right. And you look it up, it's an act of 1871, acts of the defacto 41st Congress. That's not a lawful Congress. Section 34. Section 3, Chapter 61 and 62, Act 1871 allows the corporate U.S. to control a country in the place of the natural de jure government.
Now, they declare it themselves. They don't actually have authority to do this.
They have no authority.
They just said, yea, verily, we shall do this.
We haven't had a lawful government since March 27th.
Exactly. We have a fabrication created by Lincoln. Serve the glory.
Sold itself to the crown. So the necessity for delegated authority, it is essential for a federal employee to possess delegated authority to perform a particular act. Absence of delegated authority means that the act in question was beyond the scope of the employee's duties. Now, this is federal. This is anybody.
Exactly.
State, county, whatever.
They all function under delegated authority.
And therefore unlawful. The necessity for a public employee to possess delegated authority is shown by a wealth of cases. Now,
we'll read a couple of these.
United States versus Spain in 1987.
U.S. versus Hovey.
That was 1987. Another case.
Pease, Emerson.
1986, 1988, 1988,
etc., etc.
1990. So anyway, all these are federal cases. Most of them are done in the Supreme Court. I got to list them, and there's more to go if you want.
Exactly. If you want that information, shoot us an email at Nevada Republic Network at gmail.com, and we can actually give you the transcript of the show. It has all these listed out for you. But I know Gary's tired of reading this.
No, what we're trying to prove out here, maybe it's in the next paragraph. Is that it? Is that where we entered in?
No, we got more.
Okay, no, go ahead in the next one.
So, without a lawful government to delegate this, no authority exists for these functionaries of government. They can't be delegated powers that are not lawful for the executive legislature. And that's what it is. It's an executive legislature, not a true legislature, or the de facto executive branch to have.
So immunity. Now they're saying that these cops have immunity.
Well,
Well,
not just the cops,
yeah.
the prosecutors, the judges, the other court.
So this defines how they get away with the immunity or not get away with it. So it depends on delegated authority. When a citizen challenges the acts of a federal or state official as being illegal, that official cannot just simply avoid liability based upon the fact he is a public official.
No, we hung guys in Nuremberg for that.
Right. In the United States versus Lee, this is back in 2, no man or woman in this country is so high that they are above the law. No officer of the law may set the law at defiance with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law, are bound to obey it. It is only the supreme power in our system of government and every man or woman who, by accepting the office, participates in its function, only the more strongly bound to submit to that supremacy and to observe the limitations which it imposes upon the exercise of authority which it gives. Shall it be said that the courts cannot give remedy? Citizen has been deprived of his property by force, state seized and converted to the government without any lawful authority, without any process of law, without any compensation, because the president has ordered it, his officers' possession. If such be the law of this country, it sanctions a tyranny which has no existence in the monarchies of Europe or any other government which has a just claim to a well-regulated liberty, protection of rights.
Pretty powerful stuff.
So Pierce versus the United States, it's called the Floyd acceptance, 1869 decision. These decisions, man, we take decisions back to the cases of the king and queens.
Well, exactly. We'll go reference all the way back into the 15th century.
And I have attorneys say, well, they don't go prior to 1981. Well, that's nonsense. We have no officers in this government, from the president down to the most subordinate agent, does not hold office under the law with prescribed duties and limited authority. So in Cooper versus O'Connell, a banker was indicted, acquitted, and then brought suit for the malicious prosecution against the agent who caused his regarding the rule that agents acting outside the scope of their authority are personally liable for their torts. The court stated, there's also a general rule that if any officer or otherwise acts outside the scope of his jurisdiction and without authorization of law, he's liable in an action for damages, injuries suffered by a citizen as a result thereof.
So in Estrada versus Hills, this says this ruling that agents are personally liable for acts outside the scope of their authority has not been modified or changed in any way over the years. And that case came through in 1975, and it references previous.
So it's just not a clear-cut case of immunity. They have to prove they had the delegated authority to do what they did. Without it, they don't have immunity. That's right, under their jurisdiction.
For a government agent to have some kind of absolute qualified immunity for suit or for conduct arising from the performance of their duties, they must first have a valid authority to perform acts in question. They got to have that delegated authority from above, and they got to have jurisdiction.
What's those 2 words again? Valid authority.
Valid authority. They lack such delegated authority, the immunity vanishes. This is established in Butts versus Ekomanu, is 1978. This rule clearly acknowledged by the court. And they say it was established long ago whenever any officer exceeds their authority and wrongfully seizes or levies upon property, he is personally liable for the tort of the act. Continuing on from Buck Colbath all the way back in 1806.
An attorney is a state officer of the court, firmly part of the judicial branch. Attorneys will all tell you that they are licensed to practice law by the state Supreme Court. Now, they aren't. Therefore, it is unlawful for an attorney to hold any position or office outside the judicial branch. There can be no attorney legislators, no attorney mayors, no attorneys of police, no governor.
You can have an attorneys general, though.
Oh, yeah. Yes, I know it happens all the time. However, this practice of multiple office holding by attorneys is prohibited by the Constitution. But all the Constitution, you don't.
It's a felony, actually, in most states, including here in the great corporate state of Nevada.
So if you read further into your state constitution, you find the clause stating this separation of powers, which will essentially read as follows: branches of government. Powers of the state government shall be divided into legislative, executive, and judicial branches. No person belonging to one branch shall exercise any powers pertaining to either of the other branches unless expressly provided therein. Therefore, a police officer cannot arrest a prosecutor.
Well, in court.
And a prosecutor cannot prosecute a judge cannot order a legislator to perform, and so on. You know, your prosecutors have to have a special license. Your district attorneys have to have a special license, or they can't do their deal. And you should always ask if those prosecutors, those district attorneys, have the necessary paperwork. A lot of them don't.
They need to be able to present it to you.
That's right. So delegated authority or not, never before have public officials violated Americans' rights or privileges, requiring millions of lawful businesses shut down their doors.
But it's okay for Fancy Nancy to show up in one of those closed salons to get her hair done.
Oh, she got mad because they filmed it.
Oh, exactly. She got mad. She got mad because she got caught.
Throwing tens of millions of people out of work. They did so at the command of one particular group of supposed experts, those in the medical and public health field,
who can't even agree on what's going on. They constantly are contradicting themselves and each other.
Yesterday, 500 German doctors are now speaking out against this fraud, whom view their mandates as eliminating one particular health risk with every means but at their disposal. Does any of our articles of freedom list the medical and public health funds, one of the three branches of our government? Which one of the three government branches, legislative, executive, or judicial, do these private corporate departments fall under to have Constitution delegated authority?
I'll give you a hint there, ladies and gentlemen. They don't.
Oh.
They do not possess a delegated authority.
Where does their authority come from? Not common law. Governors and mayors started rolling out one emergency decree after another. They call them mandates. They don't have no right to do a mandate. To terminate economic activity, seemingly heedless of the consequences, the lockdown mandates employed mind-numbing, arbitrary distinction.
Oh, heck, I don't know if you heard this one, Gary, but yesterday our illustrious corporate governor misused the reverse 911 system and that nifty system they installed on your phones to drop a message saying, hey, we're doing COVID testing. How is that in an emergency? How is that something, important enough to say, yeah, I need you to stop what you're doing and look at your phone for it?
So where did their lawful delegated authority come from? This question is for you people that call yourself Americans. U.S. citizens just don't need to worry about it. You are blind followers of foreign corporations stealing our articles of.
That's right. If you're one of those 14th Amendment citizens, don't worry about it.
You can fly that military battle flag of the crown of the Queen Elizabeth. They're U.S. citizens.
And that's okay. Yeah, that's the end of our scripted stuff. But we got 3 minutes here. I'd like to still, yammer at you a little bit. It's like Sam Adams says to apart from us in good taste. We'll forget you ever were our brothers. Let those chains sit okay on your shoulder. It's all right. I'm not going to take them, but you can have them.
Yeah. You want to be American State National, unregistered to vote. You can't vote for the corporate system unless you're a corporate citizen. Unregistered to vote for her. Fly the civil flag. Fly the state flag where you was born at. That signifies your nation. And then you'll have to do an assumed name certificate.
Exactly. Reclaim your birth bond.
Yeah. There's a couple other things. And that's all in the U.S. Code. Tells you what to do. But it's your obligation to read that U.S.
Exactly. If you don't understand the laws that are out there, the codes that are out there, the rights that you have, there's nothing that Gary and I can do for you if you're not willing to put in that work.
And just remember, American nationals, they only have to follow the Constitution and common law. you guys got the U.S. citizens got these code regulations, statutes, all pay attention to. I mean, that's ridiculous.
Billions of pages of regulations that you need to follow every day.
And constitutionally elected sheriffs are not required to follow these code, statutes, and regulations. They're only supposed to follow constitutional and common law.
Exactly.
Otherwise, they're not a constitutional sheriff.
Precisely. They're a corporate sheriff.
That's right. And if they receive corporate Federal Reserve notes, they're definitely a corporate entity. And they, under the Supreme Court ruling, they have to have a contract to even deal with you.
Exactly. They need to have, and we've had a show on this. Good show to go back to and watch. Got to go back and watch our show on jurisdiction.
So with that, all that confusing reading we did for you, we put out sometimes we put out our scripts out there at Sunseekers with Miss Mary out there on the counter, and you can pick up some copies of our shows there, or you can find us on Facebook or YouTube.
Facebook, YouTube, Twitter.
So thank you for joining. Gary Bergman.
And I'm Michael Runion. Remember, Chucky our law, our day will come.
And remember, join us Labor Day, 8 o'clock for the rally, 372 and 160 for Labor Days. Support and show your gratitude for the building trade. Thank you.
Have a good evening.
We'll see you Saturday. Bye.